developments in the law, like the antitrust case against Microsoft, that was over 20 years ago. I started really learning about the Constitution in 2007. And my dad was a lawyer for nearly 60 years, but really didn't explain very much about the law to me. He just wanted me to become a lawyer. I didn't become a lawyer. Something that I would have never thought would ever happen in my life is I ended up taking the city of Toronto to court, first to Superior Court where I lost, and then to the Court of Appeal where I lost. Anyone can read the story, of my court challenge on Off Guardian, if people know that site, off-guardian.org, and simply look up my name or look up Toronto or look up Constitution. The story is called Honey, I Shrunk the Constitution. So yeah, and all of my legal arguments there, anyone can look at them and anyone can look at the court decision and try to figure out, how the court decided how they did. It's up to them to evaluate it for themselves. So through that whole exercise, I spent about 250 hours on my case. I'm out over $10,000. I did it all myself. I had absolutely no help, but I'm out over $10,000 on my challenge because it cost me over $5,000 in terms of just transcription fees, court filing fees, transportation, printing. Printing is very, very expensive. People don't realize. And as well as costs for $5,000, which were ordered against me. That's a whole other thing, but yeah, and this is at the highest court in the province, and essentially the only thing I could do is challenge it at the Supreme Court, and they have to grant leave. They only hear about 70 cases a year. So through that whole exercise, through that whole song and dance, which was very, very serious, it was some people will outright ask me, well, wait a second, you challenged a parking ticket. And I said, well, my challenge of the city of Toronto's authority to cancel the charter, to cancel the will of the legislature, and to cancel the power of the courts constitutes a superpower. And essentially, my case had as much to do about a parking ticket as the American Revolutionary War had to do about today's equivalent of a $2.50 per pound tax on tea. It is about the power and the authority of government to cancel our rights, to override the law, to supersede, longstanding British common law doctrine, tradition, and practice. So I challenged it and I lost. And I challenged it simply because, irrespective of the little that I knew about the law at the time, the city of Toronto, and this completely applies to everything that has been going on throughout 2020 since March, is that they claim this authority to set aside the charter. So literally set aside something that at the time I just knew it as the highest law of the land. That's what I would have called it at the time. In section 52 of the charter, it explicitly says this is the supreme law of Canada, and everything that is in conflict of it is of no force or effect. So it says it right there. I knew that without reading that specific section, and I challenged the city of Toronto based on their opinion that they could set aside the charter. So I saw this violation of our rights coming, but being in finance, I figured it would be, and this was all in my evidence before the courts, is that I thought it would be a financial crisis, that we would be pushed into an inevitable financial crisis. Never thought it would be a virus or any type of response to a virus or any of the narrative surrounding it. I just thought it would be a financial crisis because there is a sort of financial law of gravity that if you take up a lot of debt, and the GTA is the most indebted regional jurisdiction on the face of the earth, literally on the face of the earth. I thought that the chickens will come home to roost eventually. And when that happens, they're going to take away our rights. And one of those rights would be essentially to be heard in court. So they would transition everything to be heard in front of an administrative tribunal, which I think is coming, by the way. Right now, they're saying all the stuff to do with the Quarantine Act and any of these fines are right now they are by definition, they're quasi-criminal. They have to be heard in provincial offenses court before justice of the peace. That's how the law reads. But they could change it, and I do expect them to change it to an administrative penalty regime, because they did that for parking tickets, and people think, well, who cares? It's just parking. It doesn't mean anything. Well, they could do this for anything. They have done it for many different laws. But that said, they've not transitioned some sort of a criminal or quasi-criminal scheme that is offenses that must be heard in court and turn them into some sort of administrative penalty scheme. And there's really very little difference between the two. The big difference is you really lose all of your rights under an administrative monetary penalty scheme or system. So they could do that here, saying, well, you're guilty of violating either a mandatory masking law, or you didn't get a certificate of vaccination, so you violated the law. You're not allowed to be heard in court. You're to be heard in front of a tribunal. You're guilty until proven innocent. Your right to life, liberty, or security of the person is not being violated. Which they could argue if the vaccination itself is something that is not injected into you, it is some other mechanism, like it's inhaled. I know one of the vaccinations that has been trialed, that is being trialed, is an inhaled version. So they could say, well, it really doesn't violate your life's liberty or security. So, Section 7 is not triggered. Section 11 is not triggered, and therefore it does not constitute an offense, and you have no rights. You are guilty until proven innocent, and you have to pay a big fine, but we're not going to call it a fine anymore. We're going to call it an administrative monetary penalty. We're going to say it's non-punitive, it's administrative, and you simply do not have the right to be heard in court. And you don't even have the right to bring a charter challenge to the charge, because you don't have Section 7 or 11 rights. And Section 2, well, it's limited because it's something that we can do away with in a free and a democratic society. Again, that would be an opinion of the government, and it's up to people to challenge in court. And so far, no one has challenged anything in court. So that's essentially my little background, and I will move into the law now regarding what rights do we have, what rights do retailers have, what rights does the government have, what rights do the police have, and what can you do to assert your rights and challenge any of this in court or in front of the Human Rights Tribunal. So I'll start by saying we actually have an extremely robust framework under the tyrannical coronavirus response, which is it is provincial in terms of its legal origin. In most countries in the world, all of the coronavirus response measures are federal, so they're at the top down, from the highest level of government, from the federal government down to local. In Canada and the United States, we're outliers, where our responses are provincial or state, and from the provincial or state, there are additional powers granted to the municipalities, because the municipalities get all of their powers from the province or the state, and from there, then they exercise their powers to charge people with an offense, to essentially execute the provincial law or state law. So, and again, in other countries in the world, everything is federal, and it's dictated top down, and that's how they decided. In Canada, it didn't happen because literally one MP, Scott Reid, from, I believe, Kingston, it's from Eastern Ontario, and I've actually talked to him personally on several occasions. The latest being at the Runnymede CCF legal conference back in February, near the end of February. So this is someone who's long been a conservative libertarian, and he showed up when he was specifically told not to, and because he showed up and guaranteed there would be a debate, they backed down, and the Emergencies Act was not invoked. So as a result, yeah.
And thank you for bringing that up, because I was actually always questioning why Trudeau actually didn't do federal one, and then thank you. Until today, I actually didn't know. I mean, I was so busy, didn't even look into that, but. Myself, that's what I'm learning for sure, and that's already amazing to know that, because of one person, we actually have more freedoms than other places in the world.
It literally, it's not overstating it. It literally was one man who stood up, and he's from the same region but federal. He's an MP.
Yeah.
As Randy Hillier, I believe. He's either
Close enough. I was
the
very
same
close,
region.
so like same one. Yeah.
Yeah. So Randy Hillier is literally the one MP other than Belinda Carahalios, who stood up to the essentially the permanent state of emergency
And she
that
did
was
that
declared
recently.
by.
Randy Hill has been first one back from springtime.
Yeah. Well, Randy Hillier is the only one who's really spoken up and is actively speaking up. Like
Yes.
Belinda Carahalios is, she spoke up and it really hasn't been heard from since, at least anywhere
Yeah.
public. But and Randy Hillier has and is being very, very active essentially every single day. Scott Reed, I don't know. I don't recall seeing him being active recently, but he was the one who stood up. And as a result of that, everything was done at the provincial level. So what kind of rights do we have at the provincial level? So what makes it more difficult being done at the provincial level is I can't just tell you have a set of laws that you can follow that everyone from BC to New Brunswick, Newfoundland, Ontario, wherever can follow and exercise those rights under those laws. I can't, because all of the laws are provincial. Charter is national, but it really doesn't apply except to government and to police. So that is helpful in some circumstances, but it's not helpful when dealing with other citizens. It's not helpful when dealing with businesses. But for anything that's constitutes government, it is. For everything else, regarding masking, regarding anything else, any types of restrictions, most of that will be at the provincial level in terms of businesses. So what kind of rights do we have? We actually, as I said earlier, we have a very robust framework of laws, of rights conferred upon us by the provinces, depending on where you are. And they're actually very similar. They're different laws, but they're very similar in terms of their framework. So every province has a coronavirus response. So it's from the province. The provincial legislatures, they are sovereign authorities. Essentially, we have parliament, we have the legislatures, we have the executive, which is enabled by the legislatures or parliament, and we have the courts. Those are the sovereign authorities in Canada. And that's generally how the British common law system works. So the municipalities are not in the Constitution. They have absolutely no power. Those powers are granted by the provinces or states. So we had the coronavirus measures passed in March across all of Canada and the United States, and those measures, they stipulate penalties for, the lockdowns were brought in and things like that, but not masking. Masking was absolutely not mandatory back then at all. Some people wore masks. Actually, not too many people did. More and more people did. But masks were not mandatory in that whole lockdown stage 1 phase, which really applied, but again, provincially or by state, they were applied, and people had to lock down. So the coronavirus measures were then delegated. The powers were delegated to the municipalities, and the municipalities enacted their own measures. So the province did it, and then each province did it, and then their municipalities did it as stipulated and empowered, delegated by the province. So in Ontario, they did it through our Emergencies Act, and eventually that would become this Permanent State of Emergency Reopening Ontario Act. And all of these regulations were made under that act. So I have to explain the difference between, because people say, it's been quite popular on Facebook to say, well, there's some sort of an order or regulation, or there's some sort of a bylaw, and that's not the law. Well, it is the law. It's called subordinate legislation. So subordinate legislation is just as it sounds. It's low on the totem pole in terms of the law. So you have right up here, you have the Charter of Rights and Freedoms, supreme law of Canada. Right below that, you have quasi-constitutional law, which is really the Human Rights Code, as asserted by the Supreme Court in 2015. Then you have ordinary statute below that, and then way at the bottom, is you have subordinate legislation. So subordinate legislation is executive legislation. They're executive orders. They're just called orders, bylaws, or regulations. So that regulation, those types of that type of legislation, subordinate legislation, it has the full power of law. You can be fined, you can be charged, you can be arrested, you can go to jail on subordinate legislation. That is how it's always worked, but subordinate legislation must be enabled by some sort of a statute. So the difference between the two, again, people say, well, it's subordinate. How do you get this type of legislation, into law? Well, there's a big difference between statute. That is what we kind of ordinarily know as the law. They're called acts. People have heard of there's the Emergencies Act, or things like that. They're the Human Rights Code, or Act, and there are all sorts of act. The Trespassing to Property Act. Those are all statutes. Statutes go through this process where there's one debate, one reading, then there's a second reading and debate, then there's committee, and then there's a third reading and debate, and then it's signed into law by the lieutenant governor or the governor general. If it's lieutenant governor, it's the province, the governor general if it's Canada. And that's how it works here. And it's similar in the US. That's how our systems work. So essentially, something that goes through that rigorous process of debate, of 3 debates and committee, is obviously, you don't need to be a legal expert to know that holds more legal weight than something that is simply made. So regulations, orders are made. Bylaws are generally passed with council, but they're still subordinate. They don't have power without the province or the state. So those types of things are made, especially orders and regulations. They're made with the stroke of a pen, or it literally is a stroke of a pen, because it can't be done electronically. It has to be signed, and then it can be put into the system electronically. So something like that is subordinate by its very definition. It can simply be made. There's no debate. Anytime you hear about some sort of executive power, that is subordinate. I know it sounds like very high up, but it is subordinate. Whether you look at it from the standpoint of the provincial minister, or medical experts like the chief medical officer, or you look at it from a tribunal, or you look at it from any other perspective where you don't have legislators making the law, you have some kind of, it's called a subordinate entity, when or the administrative decision maker. There's different boards, tribunals, committees, things like that. They can issue these types of subordinate legislation. So now that I got that out of the way, most of the laws in the province are subordinate. So they are enabled by the province in these various acts from each province. And then the subordinate legislation, that is regulations, orders, and bylaws, are made or passed. The bylaws are passed, the other ones are made. And for the most part, in Ontario and in other provinces, we have these pieces of legislation that are really made by the medical officers. So the chief medical officer will make these regulations, and you have to follow them, and the municipalities have to follow them, and that's it, unless challenged by court. So what else do we have? That is the law as written. So what do we have here in Ontario? And I'm going to go over Ontario, and I'll briefly go over a couple of other provinces. So in Ontario is actually the easiest to follow. The other provinces are very difficult, because there are all sorts of regulations and orders, and you don't know what is what, and you have to look at each one very closely, and it's difficult to follow. In Ontario, we have a bunch of these regulations made under this Reopening Ontario Act. Previous to that was the Emergencies Act, or whatever you call it, the Emergency Management Act, etc. Whatever it's called. So we have these clearly delineated regulations, and you can look them up, and they're easy to check on this. If you look up Reopening Ontario Act, you can look at the regulations. In other provinces, it's very, very difficult, because there's regulations and orders, and there's all this stuff. So you literally have to look at the masking guidelines and then see what it says there, and you could eventually look up the law. It's hard to do. For my whole court challenge, I brought 48 cases to court. So, and we're talking thousands of pages, and I could go through that, and it's actually very difficult to find out what the law is in a lot of provinces, but Ontario is actually fairly simple. So we're lucky to be in Ontario, where you can actually look up the law fairly quickly and find out what your obligations are under the law. So in Ontario, what rights do we have? And again, this is the same for all provinces. We have human rights legislation. So every province has its own human rights law or human rights code. Every province has its own coronavirus legislation, and then the subordinate legislation below that. Every province has its own privacy laws. That's something that is actually not discussed. It has not really been brought up even by Rebel News or anyone like that. And they're all very, very important. And then, of course, every province has its own trespassing laws, which have been cited by Costco and others for kicking people off of their property. So okay, like what types of rights do we have? So number one, under the coronavirus legislation in Ontario and in other provinces with the legislation and subordinate legislation, we have rights very clearly in the legislation. In our legislation here under the act that was passed in July, which is the Reopening Ontario Act, we have these regulations which are made. So it doesn't say it in the actual statute in the act. It says it in the regulations. So we have different regulations. One regulation we have 8220, which is stage 1. And there really aren't any rights there, just a law. It's a blanket lockdown. So there's nothing about masks in there. This is from months ago. There's nothing about masks in there. Then we have stage 2, when they started reopening. And that's in stage 2, that the regulation is called 263/20, 263/20. And then we have another regulation, which is for stage 3, 364/20, 364/20. But both of them are exactly the same in terms of section 2, subsection 4 under schedule 1. It sounds complicated. You can look up these regulations easily. You'll find section 2, subsection 4. It specifically covers exemptions. And in section subsection K, it says is reasonably accommodated according with the Human Rights Code. So and there's also in G, it says has a medical condition that inhibits their ability to wear a mask or face covering. So bottom line, very simple. It's right there. It's in the provincial regulation, and that regulation must be followed by the municipalities. So and there are 2 such regulations, as I said, and they both explicitly allow exemptions on the grounds of medical grounds and also Human Rights Code. Okay, so what do we have other than that? And that's substantial right there. We have the Human Rights Code, because Human Rights Code is specifically mentioned. Actually, before I go into Human Rights Code, I should go into the local bylaws or orders. So in Toronto, you have a bylaw, 541/2020 is the bylaw. That's the mandatory masking bylaws that applies to businesses. There's another one, 542, which applies to residences, that is multi-dwelling unit residences, apartment buildings, things like that, condominiums. But 541 is the bylaw, and in 541, it very explicitly says that, again, none of this stuff, it doesn't require a legal expert to understand it. In section 2A, it says exemptions, and that's 2A, and then subsection 2, persons with an underlying medical condition which inhibits their ability to wear a mask or face covering, and then subsection 5, persons who are reasonably accommodated by not wearing a mask or face covering in accordance with the Human Rights Code, with the Ontario Human Rights Code. So whether you look at it from the perspective of the province, which which delegates the power to the municipalities, or you look at it to the municipalities themselves, which have to echo the province. They must. That's it. That they're creatures of statute. They must get their power from the provinces and enact the power in accordance with whatever the power the province has given them. In the city of Toronto, you have the regulation 26320 or 36420, depending on stage 2 or stage 3. We don't know about tomorrow. We still don't know about tomorrow, what's going to happen, because there is no regulation for tomorrow. It is still, we don't know what the law is for tomorrow. In 6 hours time, we have no idea what the law is for lockdown. If they go back to stage 1, then mandatory masks are no longer, they're no longer mandatory because it's not in the regulation. I expect it will be updated. It will be amended, that regulation. 8220 is called, it's called 8220, that regulation. It will be amended. I expect it, but it hasn't been. It just says lockdown, nothing about masks in there.
Yeah.
So we don't know what the law is, but in respect to lockdown, going back to lockdown, but previous to that, with their ridiculous color coding schemes, we know what the law is, and the law clearly allows for exemptions based on medical or the Human Rights Code. That's in the regulation, the regulations, there's 2 of them, and that is in the bylaw for the city of Toronto. It very specifically says that. Okay, so the next thing is, and I'm outside of Toronto. I'm in Durham. I lived in Toronto for my whole life until 2016. I'm in Durham, and I'm in Oshawa. What do we have here? We have the class order of September 28th, made pursuant to Section 22 of the Municipal Act. So they're allowed to make those orders. And what does it say? Essentially the same damn thing. It doesn't mention the Human Rights Code, but it mentions if you have trouble breathing and a bunch of other stuff. Anyone, and of course, no proof is required. There is no proof required for any of this stuff. You are allowed to cite an exemption based on medical grounds or human rights grounds, or, specifically grounds that you feel you have problems breathing through the mask, which I think is quite reasonable for a lot of people, especially people who have anxiety, and that's another ground. But the point is, you have the right, and no one can tell you you do not have the right, because it is in the provincial legislation. It is in local legislation. All of the municipalities are the same. They're very, very similar. So I've cited the 541/2020 bylaw in Toronto, and I've cited the class order, the Durham class order of September 28th, where it very clearly states what the exemptions are, what grounds there are. Then Durham class order, it does not mention the Human Rights Code, but in the regulation it does, so it doesn't matter. And you have the right to assert those exemptions and to to be accommodated. That is the law as written, not as some Costco or anyone else would like it to be written, and frankly not even how we would like it to be written, but that is the law as written. So we have those rights. So what else? So then so I mentioned the Human Rights Code. I was about to go into that, and I wanted to go into the local laws first. So the next thing is the Human Rights Code. What rights do we have under the Human Rights Code? And the Human Rights Code is stupid simple. Human Rights Code provides for, and I have to go back here and specifically read it to you, because it's
by the way, just to let you know, we have about 70 people watching us on Facebook.
Okay, fantastic. So
okay, questions as well, but I'll give you time to express everything, and then we can.
Yep. Yeah, there's not a whole lot more to go. I will mention the Privacy Act and the Charter and the Police Services Act, but essentially the Human Rights Code is being developed over, we're talking several decades here. And over the last 20 years, the Human Rights Code, whether it's provincial in any given province or federal, has been greatly strengthened by this. Jessica Yaniv said he had to be waxed, and as a and things like that. And there's compelled speech for gender discrimination and things like that. There's all sorts of stuff that is being enabled by this kind of very, very liberal interpretation of Human Rights Code, and that is what's occurred over the last 20 years, and it works to our advantage in this case. right at the top of the preamble of the Ontario Human Rights Code, and it's similar if you look at the Alberta Human Rights Code. I've looked at other ones, but I've looked at the Ontario and Alberta Human Rights Codes or Acts very carefully, because of what happened with that a man being ejected, very forcefully from that Costco in Edmonton. So I looked at what rights they have there, and I compared the two from in Ontario and Alberta. So right at the very top, and Alberta's is worded similarly. This is the preamble. Whereas recognition of the inherent dignity and equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world, and is in accord with the Universal Declaration of Human Rights as proclaimed by the United Nations. It is absolutely critical that you understand that. Dignity. What is inherent dignity? Well, inherent dignity does not constitute being dragged out of a Costco and being embarrassed and for exercising one's human rights. That is an utter goddamn disgrace. That is not what it says in the Human Rights Code. It is not what it says in Ontario. It is not what it says in Alberta. It is not what it says in Saskatchewan or anywhere else. That is why the Human Rights Code exists, to protect our inherent dignity. I cannot say it strongly enough. Under Section 1, again, right under the preamble, every person has a right to equal treatment with respect to services, goods, and facilities. Services, goods, and facilities, including private businesses, and especially including private businesses in addition to the government, without discrimination, because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, marital status, family status, or disability. The next section, Section 2. There's 1 and 2. Okay, so I'll just read the. Actually, I'm just looking here. I'll read them both, just so it's there. I'll read it quickly. Number 1. Under Section 2, every person has a right to equal treatment with respect to occupancy of accommodation without discrimination, and all the same kind of stuff is there. And then it says 2, every person who occupies accommodation has a right to freedom from harassment from the landlord or agent or the landlord or by an occupant of the same building, same kind of thing. And then you scroll down, so people think that's where it ends. No, that is not where it ends. You actually have additional rights with respect to freedom of expression. So I just want to read it to you. It's quick. Sorry, I'm going here on one of these idiot touchpads. Okay. Sorry, I'm not seeing it here. Hold on. I just want to type this in here. Hold on.
Just by the way, guys, to let you know, I am watching your comments. Whoever's writing questions, I wrote some of them down. We can come back to some of the questions. So definitely continue commenting with your questions or comments you guys have. We'll discuss them with Chris once he completes the basic framework that we wanted to establish. And then we'll have a discussion. So keep sharing the live stream, guys, so more people can join and get this information. I am recording this too, so it should be posted. I think it might be posted automatically on Facebook, as well as I have a recording that I'll post on YouTube later as well. So.
And by the way, with respect to Costco, there's something else that I forgot to mention, which is right to contract.
Yes.
Right to contract on equal terms of the discrimination, and everyone who's a member of Costco has entered into a contract with Costco, which was last updated on April 1st, 2019. No mention of mandatory masks in there. No mention of masks at all. So you have they can mandate whatever they want, but it has to be in accordance with the human rights law. So I want to go to with respect to freedom of expression here. I just want to find it because I thought I had it ready to go, and I don't have it ready to go.
Okay.
And if I can't find it now, I will. Okay, hold on here. Okay, got it. So sorry, I did see it earlier, but the way that again, I'm on a different computer to get the chat to work properly, and as a result, I didn't have it ready to go. So I've already posted this on Facebook a number of times, which is there's sections 1, 2. Now I'll also say section 3 because of the right under contract, and section 13 of the Human Rights Code. So section 13 says, announced intention to discriminate. A right under part 1 is infringed by a person who publishes or displays before the public or causes the publication or display before the public of any notice, sign, symbol, emblem, or other similar representation that indicates the intention of the person to interfere, infringe a right upon under part 1, or that is intended by the person to incite the infringement or a right under part 1. And then it says opinion. Subsection 2, subsection 1 shall not interfere with the freedom of expression of opinion. So it's really section 13, subsection 2. Freedom of expression of opinion. So one could easily argue, and I would say people are specifically arguing that by not wearing the mask, yes, one is exempt. That has been established. One is exempt on medical grounds or on other human rights grounds. They do not need to provide proof. But separate to that, I think everyone is indicating by not wearing a mask that they do not comply. They do not agree. They do not obey. We do not consent. And we are expressing our opinion. And the Human Rights Act very specifically allows that free expression of opinion. And nothing in the law, I mean, I underline nothing in the law allows us in any way or disallows us from the free expression of opinion on Costco grounds or anywhere else, as long as it's not some kind of loud display. It's simply not wearing a mask is freedom of expression. And until that is somehow denied by under the law, there's nothing in the law which denies it, and there's no interpretation of the law that could deny it. We have that freedom of expression. We don't need some sort of a wristband or some ridiculous notion that we need to follow some kind of government rule or store rule to say we don't want to wear the mask. We don't want to wear the mask. We're expressing our opinion by doing so. So all of that is very, very vital to just remember sections 1 to 3 and 13 of the Human Rights Code for Ontario. Alberta's is similar. A lot of the human rights codes are similar depending on where you live, what province you're in. But again, we all have that. We all have that, and the wording is very, very similar. The last thing is, well, the two other things I wanted to mention, and I'll briefly go over the charter, but the two other laws I wanted to mention, one is the privacy laws. So we have the Freedom of Information and Protection of Privacy Act, and it's called the same thing in Alberta as well, because I looked it up there too. In Ontario, we have under sections 38, I'm not going to read them out this time, but under sections 38 and 39 of this law, as I said, Freedom of Information and Protection of Privacy Act, or FIPPA, F-I-P-P-A, FIPPA. We have under sections 38 or 39, which do not allow the disclosure of personal information, and that's under section 2 of the Act. Unless specifically authorized by statute, which is specifically not authorized in statute. The exact opposite is stated, saying that, well, it's actually not in the statute, but it says outright in the regulation and in the bylaws and local orders that there is no requirement for the production of any type of proof. So not only do you have the local bylaw or order and the regulation, but you also have this FIPPA, which is called the same thing in Alberta, and I think it's there at sections 33 and 34. And so there's no law that requires anyone to produce proof of medical exemption. Now, the province could change it. They may very well change it, but they haven't changed it. So until they do, they have to change the regulations. They have to change, then the local bylaws or orders have to change, and then they have to change FIPPA as well. There's a lot of stuff that has to be done to disallow it. Actually, they don't specifically have to change FIPPA. It already says in accordance with the law to enforce the law. So that's something else to keep in mind. You really do not need to I'm just being complete. You really do not need to cite this, but you can if you want to. Citing more laws sometimes could be very helpful to you, especially with the police. But that's yet another right that you have that is conferred by statute. Very, very important that it's statute and not subordinate. It's the high law. And then also there is the Police Services Act. So and this is again, Ontario, I believe the other provinces have similar legislation. Ontario, you have Section 1 right at the top, and Section 1, subsection 1 says the police must uphold the safety and security and property of people and businesses. That's essentially what it says. And then subsection 2, it says the police must uphold the Charter, which is a supreme law of Canada, the Charter, and the Human Rights Law, Human Rights Code, as higher than any other law. And that is true. And up until 2015, that's something that really had to be in statute, because the Human Rights Code was not specifically recognized as some sort of above ordinary law. But in 2015, in Alberta, they have in Section 1 of their Human Rights Act, it specifically says that anything that conflicts with their Human Rights Act is inoperative, meaning it's just doesn't matter. It's completely rendered, neutered. But in Ontario, we don't have that, and I believe most or all of the other provinces, we don't have that. So the Supreme Court in 2015 recognized in a case, Quebec, their Human Rights Commission, Quebec v. Bombardier, paragraph 30, that the human rights laws in Canada are quasi-constitutional. So they're higher than ordinary law, which brings me to the Trespass to Property Act. And in Alberta, they have 2 trespass acts. These trespass acts are lower than the Human Rights Code. And that is recognized, that is specifically in statute in Alberta, where that guy was kicked out of the Costco. In Ontario and every other province where it doesn't say it has some sort of higher standing in law, the human rights quasi-constitutionality was specifically recognized by the Supreme Court. And the Supreme Court is a sovereign authority. They make the common law. So the common law, judge-made law or court-made law, is fully enforceable. It must be enforced. Everyone must abide by it. The provinces, the municipalities, the federal government, the police, everyone must abide by it. And of course, also private businesses, because the Human Rights Code, not the Charter, but the Human Rights Code applies to private businesses and sole proprietors. People have business licenses. It doesn't apply to you at home. So you can reject people on their opinions and other things like that and say, get out of my house. You can say that, but you cannot do that if you're a business. That is the entire point of human rights legislation. And you certainly cannot remove someone from someone's premises, someone's place of business, because you disagree with them. Because someone is literally, people have argued this, and of course they shut up right away because it's absolutely ridiculous. But someone says, well, what if I don't wear pants? Do I have rights then? Ridiculous things like that. And I would simply respond to anyone who makes a ridiculous comment like that, that it would be like saying Costco, by their contractual rights, can just remove someone for being, someone could just say, you're too fat, or you're too old, or you're too ugly, or we just don't agree with you. So therefore, get the hell out. Well, no. They specifically, they did have that right before the Human Rights Code. A private business did have that right. They don't have that right now, and they can't do it.
Yeah,
so
the distinction that we can always make is when people make the comparison between no shoes, no shirt, no service, or wearing a seatbelt or whatever. In terms of the shoes and service and shirts, whatever, it has to do with decency. So there's a difference between decency and forced medical procedure. And any type of face covering is considered to be a medical procedure because it alters your heart rate, it alters all the functions of your organs. And talking about the Human Rights Code, yes, there's a discrimination. So can Costco make a policy that people with turbans not allowed to come in? They have to take the turbans off? No, they cannot do that. It's called discrimination.
Yeah, but they would say, and they are saying, but they're not saying. They are saying, but they're not saying. That's what's so ridiculous about this. If Costco would simply put it in their damned contract, they would amend their April 1st, 2019 contract and give people fair notice and tell, so that is tell people about it, and then allow people to consent or not consent. Some people will just cancel their memberships, and they may not, and they won't care. But I know I wouldn't cancel my membership if that whatever they put in their contract was illegal, meaning it does not comport with the human rights legislation on a provincial basis. I would say hold on to your membership, assert your contractual rights with the Human Rights Code, because again, Section 3 of the Human Rights Code in Ontario governs contracts, and it is supreme. In terms of private businesses, it's above trespassing laws, the Trespass to Property Act. It is above the contractual laws, the common law. It's above all of that. That is what the courts have held. That is what the Supreme Court has held. So no matter how badly Costco may legitimately be fearful for its business that people will not show up, and that's a huge problem. And I do empathize with the Costco and other private businesses. I'm not going to say otherwise. I do empathize with them, but that doesn't give them a license to break the law. If they have a problem with the law, they can lobby the government, or and this is what should have happened. Businesses should have stood up long ago and said, yeah, we got to stop with this lockdown and masking nonsense, because the scientific evidence, the empirical data does not back it. But they didn't. They just went along with it. Instead, they just chose to go after the people instead, which is completely wrong. It's a hallmark of tyranny and totalitarianism. It's just plain unjust and unfair.
And
cost, yeah.
to make a comment to what you're saying is one of the foundation that the Costco is trying to do this is obviously they using the hallmark of this is for safety of our employees. So what we're doing, and then I watched Peggy whole video where she discussed this. Why? Yeah. So if you're forcing me to wear the mask, you consider to be me a threat. Why do you consider me to be a threat? Where's the medical documentation to make me sound like I'm a threat? Right? I'm not. I'm just being human. Right? And for all purposes, if someone feels non-safe, they can wear the mask and they shield themselves.
That's right. And this is I've only mentioned the law thus far. Courts rule on two things and two things only. There's the evidence and there's the law. So I haven't mentioned the evidence so far, and I'm not going to really go into it. I think a lot of us are up to speed on the evidence, but essentially, whether it's PCR testing and how many cycles they do, and for a diagnostic tool, and trying to figure out what's a positive test or not. And with respect to the efficacy of masks, the Danish mask study, which was delayed for months, literally 4 months, just came out. It showed there is no efficacy. There is no difference, absolutely no statistical difference between masking and non-masking. And this was done in Denmark, where people were all trained about exactly how to wear the mask, how to maintain the mask, to not touch the masks unless their hands were sanitized, to do all of that sort of stuff. And there were 3-layer filtered medical masks, very high quality masks, unlike the very low quality masks that a lot of people are wearing, and not washing and not handling very carefully, and they're not airtight, and there's a lot of other problems there. So when the highest quality masks were worn in the proper way with the highest compliance rate, per the study, it found no efficacy. It found that people who didn't mask, in fact, people who, this is specifically in that study, there's no paraphrasing or anything like that. I don't have it to read for you right now, but it specifically says that people who went home, everyone who went, when they tracked the PCR positive test, irrespective of that, taking it at face value, they actually found far more people who transmitted the virus were wearing the masks at home.
Yeah,
they're wearing the masks
actually
than not wearing the masks.
It's our flyers, our educational flyers.
Yeah.
The exemption side and there's education side. The first point actually says, and there's a clinical study to back that point up. It says wearing a mask actually contributes to spread of infectious disease.
That's another, yeah, and I know I'm very well aware of that study. That's a 2015 study in Hanoi, Vietnam, where they did it in a medical setting, and they just and there were plenty of other I don't know if there were studies that were done. I know there definitely were some. I can't cite them, but because of SARS, the Toronto SARS experience, there were a lot of different experiments done with respect to masking to find out if masking could stop another SARS in the future. Could masking stop any type of flu virus? And as a result of that, in 2015 and 2018, two arbitration rulings in Ontario for the Ontario Nurses Association. And the Ontario Nurses Association, to be clear, was very against this either mask or vaccinate policy for the flu. So they fought it and they won. It wasn't even appealed to court. It was flat out rejected by both arbitrators. Two separate rulings, the latest in 2018. So again, well, what's changed since 2018? What has changed? Do we have a magical virus that can be somehow stopped by masks? No, nothing has changed.
A lot of
So
people got a lot of money.
there is absolutely no change in terms of the evidence.
No.
The evidence is actually, well, it shows there really is no difference between masking and not masking. So we have all that. And then for Costco specifically, I would say very easy. Costco is in a unique position. They have more responsibility. They are in a unique position. If you walk into an ordinary grocery store, if you pay by credit card, I guess they could track it, but it's not exactly easy. It's harder to do, but they'll have your name, but they won't have your address or telephone number. To look everyone up would be difficult. But for Costco, literally they know who goes in and they know when they come out because you have your Costco membership. So unless it's true, if you don't buy anything at Costco, they won't be able to know
Majority
who's
of
there.
people you can track.
But they know exactly, they know your name, they know your address, they know your contact information, they know how you look, they actually have a picture of you, they know everything. So Costco is in a unique position to know whether any attendance of non-masked people have in any way contributed to any hospitalizations or any deaths. They would be able to say definitively, yes, these people were connected to these hospitalizations or deaths.
Well, the reality, sorry to interrupt you, Chris, is, as we know, the people that don't wear the mask actually don't get tested. It's actually the mask wearers that get tested.
That's correct.
They had that data as well available. So again, the reality is it's the case numbers and all that bogus things that happens is actually with mask wearers, right?
And that's why I didn't say case numbers. I didn't say PCR tests. I didn't say positive tests. I said hospitalizations or deaths. The bottom line is, has anyone been hospitalized or has anyone died? I said the same thing at Good Life Fitness.
Yeah.
I said, I specifically asked Good Life Corporate, and of course they didn't answer the question. I said, you know exactly who's coming into your club. And Good Life, it's actually a lot more stringent because they know exactly when you come and exactly when you leave. Unlike Costco, they don't know when you leave. Well, they know when you leave. They don't know exactly when you arrive. Yeah. But at Good Life, they know exactly, and they have cameras. At Costco, they don't have cameras, but in Good Life, they do. So they know exactly when you leave, when you come. They know who you are. They know everything about you. And in my case, they know about my exemption. They don't have to state what it is, but it's on file. Yeah. And then they say, well, we're not going to honor the exemption. So I asked them, I said outright, well, what evidence do you have that any hospitalizations or deaths have been tracked to any Good Life facilities in Ontario? Any of them? Yeah. And of course they said, well, we don't know, or they didn't admit it. They just said, well, you have to track your own public health numbers. And I said, well, only you would know that, because track and trace, you don't need to do a track and trace with Good Life members or Costco members because they already have your information. You don't need to write down your name and number. They have it. Yeah. So they're in the best position to determine the efficacy of mandatory masking. Yeah. They're in the best position to determine what the threat is, the real public health threat. And if the evidence were discovered, if there were a lawsuit against them, the evidence would be discovered. There is no evidence. There is absolutely no evidence. Or maybe there was one hospitalization at some point, and then they got out of the hospital, and that was that. That's hardly a public health threat. So,
but the reality, Chris, apparently, out of, I think, just over 10,000 deaths in Canada, I think out of the long-term retirement homes, I think it's not even like 200 people that died, apparently. Out of whole Canada. Like,
Yeah, it's I know in Ontario, I just looked up these numbers. The last numbers that I saw were, I believe it was 83.6% of people in Ontario who died with the virus,
yeah,
COVID related, were people in long-term care homes. 83.6%. And the average age of those people, I believe, were 84.8. And the average life expectancy in Canada is 82 years old. So you actually live nearly 3 years longer with the virus than without it. That is not a public health threat, is demonstrably not. Going back to the law, I mentioned all of these acts. I mentioned the Police Services Act. I mentioned the Trespass Act. So it absolutely, the Human Rights Act, the Human Rights Code is paramount. It's paramount or superior to any trespassing laws. That's the point. That is the entire point, to not have people hauled off of property because someone finds their appearance objectionable, or they want to discriminate against them on some other grounds that are laid out in the code. You cannot. That protects human life and dignity. That is the whole point. So specifically, that probably the strongest protections are against trespassing, the trespassing laws, because that is a violation of your right to go and be on someone's property duly doing business with them. If you're not allowed to do that because it's contrary to human rights code, it is illegal, and you may not be escorted from the property, period. That is the obligation of the police in Ontario. That is the obligation of provincial police. That is the obligation of Toronto police and Durham police and everyone else. That is the law. So yeah, and with respect to the charter also applies to the police and government, but not to Costco. So you could cite the charter with the police, and one of those things is Section 2. So you could literally say, when going into a Costco and a bunch of us are there and they don't let us in and the police show up, you could say, Constable, respectfully, I assert my rights under Sections 2, 7, 8, 9, 10, and 11 of the charter, and Section 26 as well. Section 2 is freedom of expression. Section 7 is right to life, liberty, or security of the person. I want property to be in there. It should be in there. Then we wouldn't have these fines. But life, liberty, or security of the person, and you may not be deprived of those only in accordance with the principles of fundamental justice. Section 8 is no unreasonable search and seizure. 9 and 10 involves arbitrary detention and right to see a lawyer. 11 is the criminal provisions, and the criminal provisions apply. And Section 26 is British common law. So the law is written, decided by the courts, but before all this, before the charter was enacted, and even since the charter was enacted, it is all important, but the charter is the supreme law. So the police have to enforce that. So if you say you're there, and literally you could tell the police, we are here to go to Costco. We are here exercising our rights, but we are also exercising our protest rights. This is a protest. Yeah. We protest these illegal measures. They can't stop you. No. They can't stop you. We have Section 2B. You have the right to free expression, to freedom of association, freedom of conscience. You have the right, and they may not take that right away from you. So literally, when the police come, you mentioned the Police Services Act. You mentioned that the Human Rights Code is quasi-constitutional, as decided by the Supreme Court in 2015. You don't need to cite, it's Quebec v. Bombardier if you want to remember it, but it's in there. And in the Police Services Act, Section 1, subsection 2, they do not have the right to remove you from the premises. You can tell the police that Costco must abide by the Human Rights Code, and that the police must tell them to let you in. Unfortunately, I have to say this, there is no offense delineated in any of the regulations or bylaws for your exemption not being honored. So if they break the law, if they violate your human rights, there is no offense in the criminal courts, in the POA courts, in the Ontario Court of Justice. There is no offense delineated in provincial law or in municipal law. It is not there, which puts the jurisdiction of any challenges of your human rights laws, the human rights laws, your own exercise of those human rights laws, squarely in the jurisdiction of the Human Rights Tribunal. One thing that this is what I've told people, be careful about going it alone. I really want a concerted, coordinated effort at the human rights tribunal level. I want 100 claims, 200 claims filed, all separate, but by paralegals. Reason being is one of the first thing that Costco lawyers will do is they'll assert that there's contract law, and they'll assert a trespassing law, and they'll assert provincial offenses, and they'll say there is no jurisdiction of the tribunal to hear this. There is no jurisdiction. And they could get it kicked on those grounds. Again, it's an error in law, but they could get it kicked. Then it goes to divisional court. Eventually, there's a divisional court review. And guess what? Divisional court review is like thousands of dollars. So someone may not have they may not have they may go self-represented. They may retain someone who doesn't know what they're doing. Again, if it's not coordinated, it's not concerted, mistakes can be made. And another issue is the Supreme Court decided earlier this year, there were a trio of these precedents, the trilogy, the administrative trilogy as it's called. And that was discussed very much at this legal conference, and the former Supreme Court justice was there, opined on this, one of the precedents. And it's called Vavilov. It's a Russian guy. He got his citizenship taken away from him because his parents turned out to be spies. So, and anyway, it went to the Supreme Court. The Supreme Court said that the citizenship and immigration, the equivalent, whatever it's called now, they were not allowed to take away citizenship, and that the tribunal on matters of law, and at all tribunals, all administrative decision makers, that is the Human Rights Tribunal, it could be a very lowly tribunal, it could be a high tribunal like the Human Rights Tribunal, that any errors that they make in law are to be, there's no deference to them. So before, the tribunals had the rights, if the legislature or parliament conferred those rights upon them, to have deference. So the courts have to defer to them. Even the Supreme Court had to defer to them, even though it didn't matter what. If the legislature or parliament said it, they had to defer. So they had to say, yeah, it's up to the tribunal, it's not up to the courts. But now the courts may essentially crush an inferior tribunal on matters of law. So if the matters of law are clearly cited by your representation, by you or your representation, and it's reviewable at divisional court level in Ontario, which is a 3-judge panel, and so you have to win there, because if you lose there, you can't. It's difficult to appeal. You need to get leave to appeal, then go to the Court of Appeal, and perhaps the Supreme Court. It's difficult and expensive. So you want to win at the divisional court level. To win, you have to have the law cited. The evidence has to be good, but the law has to be pristine. So I've cited all this stuff, and anyone who, and believe me, even with me going to the highest court in the province and knowing the rules of civil procedure, the rules of evidence, the common law, all the Supreme Court decisions, all the statute, all the regulations, the bylaws, all of that, I will nevertheless retain counsel who is familiar with the Human Rights Tribunal practice and procedure, because you don't want to get screwed on practice or procedure. There are no costs. I mentioned that there would be costs and I was actually totally wrong on that. I didn't know that in most administrative tribunals there are costs. There are no costs, but that's why it takes a whole damn year to be heard in front of the tribunal. It's a problem, but we all have to pony up and go before the tribunal in a coordinated and concerted manner. With the law being cited, I will work with the paralegals. I can't charge any money because I'm not a lawyer, but I will work with them and cite all these applicable laws and cite the Supreme Court decisions and all of that. And essentially the tribunal has to hear these cases, and they have to decide against Costco and other businesses who have violated our rights. I don't know how long that'll take. Don't give up, don't give in, but definitely, and Rocco Galati has said this. He said, literally, if you had like 50 people from each province who retained a lawyer, so 50 people kind of pooled their resources and paid for lawyers, for good lawyers, all of this would go away. It'd all be struck down by courts. All of these measures would go away based on the evidence. The evidence is not being heard in a single court yet, not one. Chris Sokocia, he's being challenged by the government. He's being charged under the Quarantine Act. And in 8 sections of the Quarantine Act, it mentions significant harm to public health. That's mentioned 8 times. The whole act revolves around that. And he's plainly not. And no one who has the coronavirus is a significant harm to public health. They don't have the evidence. If the evidence were ever heard in court, the court would decide against it and say, and if again, with counsel, it has to be done properly. The court must be forced to rule on the evidence by counsel really aggressively putting the evidence in front of the court. It has to be done right. They have to be forced to rule on the evidence. And if they are forced to rule on the evidence, they will find there is no significant harm to public health, and the cracks appear in the dam will break, but who knows when. We may have to deal with this through several more months or years even, but we have to fight back. This is a war. It's a war by other means. It is a war. Wars take time. The wars have casualties. There are a lot of people who collaborate with invaders. It is what it is. I said this is war when they said they're going to lock down Toronto again and Peel, and someone said, does that mean you're going to challenge war against your fellow Canadians? And I said, no. It's a war. It's a war for our rights. It's a war for our most basic rights, or our charter rights, our human rights, our way of life in our capitalist system. That's what we're protecting. We're not going against fellow citizens. We are going against the government. The government gets its power from the people. The people have been scared by the executive branch of government. The essentially powers for dealing with the coronavirus have been concentrated into the executive branch of government. And when you have the powers concentrated in any one branch of government, whether it's legislative or judicial or executive, that is indistinguishable from tyranny. That was said in the Federalist number 47 in, I believe it was 1791. I think it was. That's when the Bill of Rights was constructed. And then it was said in Cooper v. Canada, a human rights case in 1996 in the Supreme Court. If you have powers concentrated into any one branch, any one of those powers, which are supposed to be separated, it's called the separation of powers, you get tyranny, and you have the power of a king. And that's what we have today. We don't have the power of a king. We have the power of a scientific dictatorship, a medical dictatorship. And we must challenge that dictatorship with the evidence before a court. So if you have a chance to go in front of court, fight it. Fight it. Go out there, pray that you get a ticket. Pray that you get a ticket that you can go in court and fight. We will hook you up with counsel.
Yes.
Message me, message Vlad. We will find counsel for you. Will it cost some money? Yes, it will cost all of us some money. But guess what? That's preferable to having our rights taken away and then going to prison anyway. What are you going to do then? Yeah. What are you going to do if you have a certificate of vaccination, according to that's needed to go anywhere, to any private business, in Canada? Potentially, that's where we're headed. And it's not paranoid to say it because Ticketmaster just said it. If Ticketmaster didn't say it, I would be a paranoid nut. But Ticketmaster just said certificate of vaccination required. Every business could require it. So not only and of course, they've already said very clearly, public health authorities, numerous public health authorities have said that the masking will be indefinite. It doesn't matter about vaccine or efficacy of vaccine. If everyone gets vaccinated, if every single one of us, if we just decide to throw ourselves at the mercy of government, mandatory masking will still be there indefinitely.
For sure.
They've said it.
Then people even within our own movement will backing down. It's like, oh, we need to go away from hugs of a mask. Like, no, guys, this is just the beginning. This is the movement that just has to even go to the next level. We're not backing down. If anything, we're pushing next level. And that's exactly what should be happening. So people asking in comments, a lot of people getting actually tickets being issued. The very first question that we had showing up, are the tickets being legit under the Emergency Management Act? So if people got the tickets, are they legit tickets?
Well, funny thing about that. I got a speeding ticket right after my dad died. My dad died on April 4th. He was 90 years old. He was a lawyer for nearly 60 years. I'm sure he'd be disgusted with what happened with all of this. He would be. I know his views, and I know what he believed in and what he watched on television, what he read, and with respect to him dying on April 4th, if he died 4 days later on April 8th, he would have been classified as a COVID death. Wow. Because he fit the description. So that's one reason why I'm just absolutely livid about all of these measures, because they've reclassified what a COVID death was. The WHO actually has deaths according to respiratory. But then people expanded definition. They said anything to do with heart or kidneys or any number of other things that have actually absolutely not been tied to the coronavirus. Essentially, things that you die of when you're certain of old age.
Yeah, old age. Dying of old age, ultimately.
Die of old age. So they've reclassified it. So people, so to answer the question, I know I just kind of did a roundabout there, went a bit on a tangent. The point is that with respect to me getting my speeding ticket, I got it right after my dad was buried, and I don't know if I was or was not speeding, and I would say that in court. But honestly, I think any reasonable person, it was a total speed trap, and I think any reasonable person could have maybe going a little bit above the speed limit and would get trapped. And I mentioned this to the police officer. Now, here's the thing. I wanted to challenge it in court. You can't challenge it in court. I was not convicted. There are no courts. The courts are closed. The courts have been closed since March, I think 17th. My case was originally supposed to, when I say my case, I mean my constitutional case, my lawsuit against the city of Toronto, is supposed to be heard March 30th, but it was delayed all the way to June 16th because the courts were closed. So it was heard by video conference. But the courts are still closed. The POA, Provincial Offences Act courts, which are used as quasi-criminal courts, are used to prosecute people for violations of anything that is delineated under the regulations or under the bylaws, under the orders that are issued by the municipalities. All of that is to be heard in POA court. And even the Quarantine Act jurisdiction is in POA court, which is unusual. I thought it would be a little bit higher up, but it's in POA court. So all of this stuff is heard in front of a justice of the peace, and that's it. But the problem is you can't be heard in front of a justice of the peace because the courts are closed, only in very serious offenses, like something more serious. But all these regulatory offenses, these are regulatory offenses. They are absolutely offenses to regulate your behavior, to social distance, to mask, to keep your business closed or whatever, to have a maximum of 10 people in your business, et cetera, et cetera. Those are all regulatory, it's a regulatory framework. The POA is the Provincial Offences Act is a regulatory framework. I referenced that at length as quasi-constitutional in my case before the Court of Appeal. So in terms of fighting anything, if you get a ticket, thank the officer. Honestly, thank the officer for giving you the ticket to give you a chance to actually go to court.
Yes. And
hopefully it's actually heard in court, because Chris Sky mentioned one business owner they threatened him with $5,000 fines and then $10,000 and $50,000. It was over $50,000. And they said they're going to pull his liquor license and everything. He took it to court somehow. I don't know how he did it, but you got me, but he retained counsel and he took it to court and they threw it out. But it's at POA court. The problem with POA court is that it's not in Canley. There's no record of it. And it's the lowest of the low in terms of any type of criminal court. So in terms of it setting a precedent, the Human Rights Tribunal, as an example, does not set a precedent. They just set their own human rights stuff within the tribunal, but it doesn't count outside of there. There's no binding obligation upon anyone outside the tribunal. So that's that. If something goes outside of the tribunal, it could be heard in another court. But in a real court, it's called Section 96 of the Constitution, 1867. So the tribunals, they don't have that power. There's no power for precedent, but the courts do. So in POA court, it's a POA precedent, but it's very, very low level. To get higher, it has to be Court of Justice, which is they can overrule the POA courts, and then above that is Superior Court. Then there's the Court of Appeal, and then there's the Supreme Court. So essentially, the higher up, we have a hierarchy under common law. The higher up the court, just like the law, it's Charter is supreme law, and then the human rights law is quasi-constitutional. Below that, it's and then everything is below that, and subordinate is at the bottom. So that's how everything works here. So if you challenge something, definitely, don't pay it. If you can't challenge it, if it says, I don't know if you can even challenge, like you can take something to court electronically. I don't know. They haven't made it clear on my ticket. I'm abiding by the terms of my ticket, my speeding ticket. It says there's only two ways. you must challenge it to go with the ticket in hand and apply for a court date. So it says my connection's unstable. I hope I'm still heard. So it's all right now. So the whole point is that you get a ticket, follow directions on the ticket. So if it says you can apply electronically and it says you must do so within 15 days, do it. Apply for a court date. But here's the thing. The POA backlog right now, the Provincial Offenses Court backlog, is there are over 300,000 cases that are pending. So, okay, so here's the issue. You may not be heard at all.
Yeah.
If you are heard, it may be heard, it might take over 18 months to hear it. So in other words, all this is frankly bullshit.
Yeah.
It is
Let's get to the
coercion.
point.
It is coercive bullshit. It
Yeah.
is designed to threaten you and
Intimidate you.
it's to intimidate you, to scare you. That's what all of this is. They have, at the end of the day, they can't enforce it, because in order to make you pay the fine, they have to get a conviction in court. If you apply for a court date, if it says on the back of your ticket, I don't know what it says, but if it says you must apply in person, you can't. So just wait. But if it says on the ticket you can apply in person, but you can also apply electronically, and you must do either of those within 15 days,
So
then definitely do it.
The good question would be, obviously, whoever got the ticket already got the ticket.
Yeah.
Let's have to sort it out. And if you have questions, let us know. But
look at the back of the ticket.
Exactly, right? However, when you are getting a ticket, I think it would be a good practice to always ask, how do I file this to court? The person issuing the ticket. Technically, they're supposed to inform you, right? Or no?
Provided it's recorded. If it's not recorded, it doesn't matter. But if it's recorded, ask it. And if they say, yeah, you can go in person, and then say, well, I thought the courts were closed. I thought you can't even go in person to apply for a court date.
Yeah.
What do you think?
Yeah.
They have to know this by now. The police must know it by now, and a bylaw enforcement officer must know it by now. And if they don't know it, then, and just like if they don't know the law, the police or bylaw enforcement officers don't know the law. For ordinary citizens who don't know anything about the law, they outright say, the courts have repeatedly said, ignorance of the law is no excuse.
Yeah.
Is no excuse. But what if you're enforcing the law? Ignorance of the law is definitely no excuse. And I've heard in Oshawa here, bylaw enforcement officers have threatened business owners. They've threatened business owners and said that exemptions are not allowed. And of course, those business owners are too afraid of doing anything. So then they say exemptions are not allowed. I'm not going to say who these people are in terms of businesses that I know. They're people who I know. It's very upsetting to hear it. And they're bylaw enforcement officers who are just outright breaking the law. They're violating the law. If someone, I wish I don't have some sort of a business that I could, I would disobey. I would civil disobedience. I would disobey. I'd say, please give me those tickets.
We're getting in that point.
I would say, please give me them. And then I would and if the bylaw enforcement officer said something to me and said exemptions are not allowed, I would make sure it's recorded. I would say, what did you just tell me?
Yeah.
Exemptions are not allowed.
I was on the phone with Toronto police Tuesday. I have a voice recording. I was with the dispatcher for the communication department, whatever. She literally tells me that as soon as I said, who I am and our movement, she said, literally, she says, word for word, is that I don't think all the members of your movement have exemptions.
They have to, it's true. It is by law, it is true for them to say, well, we don't know who has exemptions or doesn't have exemptions. That's a fair comment. But as long as people say that they have an exemption, that they have you could say exemption, you could say medical exemption or whatever.
Judgment, like it sounded like she's passing a judgment and almost like casting her opinion on it. Like nobody's asked for your opinion. But the other one I liked when I was calling the 32nd division, 32 division, that's actually responsible for the Costco in New Yorkdale. The dispatcher for that division basically was explaining to me that private property, Costco private property, is the same as the private property that I live in. Like my house is the same as.
No.
I know, but he was telling me that. I have a recording of that. Like, so to show you that there's a lot of
ignorance of the law. It's disgusting. And if any of this goes to court, the police by now, they have to know. It's months and months of this nonsense. They know what the law is. And they got to know. I mean, forget about it. I mean, they have to know. It's in the damn Police Services Act. It's a second item. Right. It's a second item. And it says, human rights code is right there. So and the human rights code is referenced in the Toronto bylaw. It's not referenced in the class order of September 28th in Durham, but it's in the bylaw, it's in the regulations, it's in there.
Yeah.
So they can't say that they don't know about we didn't know that the human rights code applies to private businesses. Excuse me? Then you should not be a police officer.
Exactly.
You should lose your ability to, you should lose your employment. You should be up for administrative sanction. And frankly, here's another thing, I didn't mention this earlier. And this is absolutely critical. What I'm about to say will knock most people's socks off. It really should, because we are the only country which has this, believe it or not, what I'm about to tell you. And I forgot to mention this. It's something I've mentioned on occasion. I've mentioned it on the YouTube channel where that guy got thrown out of the Alberta Costco. The point is that well, first off, I believe, irrespective of what happened to me in the Court of Appeal, I believe that we have the best courts in the world in Canada. I truly believe it, still believe it. I may disagree with the courts on various things or what happened to me, but I truly believe it. And I believe we have the finest Supreme Court on the face of the earth right now. Now, again, I don't agree with them on everything. I'm entitled to. Their opinion, according to the Constitution, matters and mine doesn't. So here's the thing. Literally almost exactly a year, it was ended November of 2019. There was a Supreme Court case, Supreme Court decision that was rendered. And it was Kosoian, 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 Kosoian well, it's in French. It's the Montreal Transit Authority. Now listen to this and see if you can see that there's something maybe a little bit in common with what we're going through. This woman was in the Montreal Metro. She was going down the stairs, and some transit cop, or I don't know if they're transit, I believe they're transit cops. I should know this. It's a long ruling. I have looked at it before. I do know the substance of the ruling, and I do know there was a police officer there. But the point is that these transit cops pointed to this sign in French, which she could read, and said, "You got to hold the handrail." And she said, "No, I'm not going to hold the handrail." You got to hold the handrail. No, I'm not going to hold. Just like you got to wear the mask. No, I don't have to wear the mask. I have an exemption. You have to hold the handrail. No, thank you. So they said, okay. And they grabbed her and they said, give us your identification. Again, there's someone who posted this on Facebook, literally like just before our call, from New Brunswick, I believe. They said, produce your identity, produce your identity, produce your identity. And in Canada, up until this coronavirus, the coronavirus measures came into effect, we never had to produce identity unless we were the operator of a motor vehicle. So if you were the operator of a motor vehicle, you had to produce your identity, you had to produce your insurance and your ownership. And that's their right, the police it's your obligation to produce it. But other than that, if you're walking down the street, and this happened with all the carting that went on in Toronto, they asked people to produce their identity, and if people said no, well then their rights were sometimes violated. I can tell you, but prior to this, and there's a big difference between the United States and Canada on this, and in other countries. We had in the G20 back in 2010 when that happened, tons of people were forcibly searched for their identification. The police are not allowed to do that. They're not allowed to do that. They're only allowed to do it with a lawful arrest. Otherwise, you're under no obligation to produce your identity. However, with one of the regulations that came out, they got rid of that. I'm not going to find it now, but it's one of the regulations in Ontario says that people are required, with respect to one of the offenses, with social distancing, with respect to business, with respect to masking, that people, actually, I don't know if it specifically says masking, but it includes masking. That's the point. They have to produce their identification to either a police officer or bylaw enforcement officer. And it's temporary, but nevertheless, it's there. So that's called stop and identify. In the United States, there are some, hold on, let me get rid of that. So there in the United States, there are stop and identify states. So some states require you to produce your identification when walking down the street, or when you're doing anything but driving a car, operating a motor vehicle. That is a right you do not have. You do not have the right to not to refuse to give them your identification. And that's a huge problem. But that has been upheld by the Supreme Court in the United States. I think 2006 was when it was really first upheld by the Supreme Court. So that's really problematic. But we don't have that in Canada until now. So, and it only applies to coronavirus offenses. So if they ask you, if you're walking down the street or you're doing anything other than operating a motor vehicle, if they ask you for your ID, you still don't have to produce it. That has not changed, even with these tyrannical measures. It has not changed. There is no stop and identify statute in Ontario, anywhere in Canada, and none of that has changed. And anyway, so going back, I know it went off on a tangent again, sorry, but going back to this Kasoyan case decided by the Supreme Court, she said, I'm not going to hold the handrail. They took her into custody. They forcibly searched her for ID. Again, no stop and identify statute in Quebec where it happened. And then they detained her for half an hour, and then they let her go. So they took her. The charge was prosecuted in court. She beat the charge. I don't recall on what grounds she beat the charge, but then she sued the police officers. She sued the Montreal Transit Authority. She sued the police officers. She lost very badly in Superior Court. She took it to the Court of Appeal, lost very badly again, but there was a dissent. Took it to the Supreme Court, unanimous. And here's the key. There are two really big keys to this, which makes this truly unbelievable and unprecedented in terms of the common law, in terms of comparing it to anywhere. Other British common law jurisdictions, Britain, Australia, New Zealand, United States, we're a small crowd. That's why they're really aggressively going after us with these restrictions, because they want to destroy British common law. They want to completely obliterate it. So with respect to what happened in what the Supreme Court decided, they decided that not only, they decided that the officer should pay out of pocket for damages. First time that's ever happened. In the United States, they have qualified immunity. Anyone who's an agent of the government has qualified immunity, has had qualified immunity from just brazenly breaching their Bill of Rights. And they've had it since 1982. We don't, and it's problematic because in the United States, they don't have constitutional damages inside the Constitution. They're not there. We do in Canada from the Charter. Prior to 1982, we didn't, but in 1982 with the Charter, we have Section 24. Section 24 of the Charter allows an appropriate and just remedy for anyone whose rights were violated. And Section 24, subsection 2 allows for evidence to be thrown out if it's obtained illegally. So we have that. It's in the Constitution. It's the highest law of Canada, supreme law of Canada. We have that. Now, here's the thing. In this Kasoyan case, her lawyers screwed up really badly. They didn't file a notice of constitutional question. They didn't serve it on the attorneys general, which you have to do to assert your rights. You have to do that. You can assert your rights in front of the police officer, but if going to court, you have to actually serve on the attorney general of your province, the attorney general of Canada. You have to serve them with notice. You must do it. Otherwise, you have your rights can be violated legally. They're not violated, but essentially, there's no remedy. They say there's no, at least in Ontario. I don't know what it says in Quebec, but nevertheless, you must do that. You must assert your rights properly. So I told Chris Sky that he's going to do that, but you must assert them. Otherwise, you won't be able to achieve the remedy that you want. You won't be able to get it. So what do they do in this case? Even though her lawyers screwed up and they didn't assert her rights properly, not only did they find in her favor, they made both the transit authority and the police officer in question, they made them all pay. They made the transit authority pay, and they made the police officer pay something like $20,000 out of pocket. That he had to personally pay it. And that's the first time that's ever happened anywhere. And it happened like right on time for this. So literally, if police officers decide to arrest us and forcibly search us, even though we've cited exemption, we cited the law, and they forcibly arrest us and they detain us, not only is Costco liable or any of those private businesses are liable, and they have to pay up tens of thousands of dollars for their violations and calling the police on us and ruining, like really ruining our dignity in front of other patrons. But also the police themselves will be, because of Kasoyan, especially if you present the law to the police, you present the law and they decide to do it anyway, it's an abuse of power, it's bad faith. There's no excuse for that, and they will have to pay out of pocket. Not their union, they will have to pay out of pocket, and the police services will have to pay out of pocket. There's no way out. There's no way out. But it hasn't been challenged yet. What I'm telling you right now, it's one precedent. It's a critical precedent. It should knock your socks off, because no one else, no other Supreme Court in the face of the earth has ever ruled like that. I don't know.
At the end of the day, individuals would
Yeah.
not want to take that responsibility. And that's what we actually have working for us. This is amazing. This is actually very exciting. I'm actually excited about tomorrow now. We'll keep it still hush hush, but I'm excited about tomorrow.
Yeah, and that's it. We will assert our rights. We will produce the rights on paper for Costco and the police to see, and the police must uphold our rights. They must. That is the law. So they must. The police not only cannot arrest us or do anything and tell us to leave the property. They must tell Costco to let us in. And if they don't do that, they're not enforcing the law as written, not as Costco wishes it would written, but as written. Now, but as I said, the problem is I will have to look up the regulations when they're updated. We're right now, we're at 8 o'clock.
I guess we'll check it in the morning.
And I don't think I'm going to look right now to see if there's anything updated, but I don't see anything that's been updated.
So to follow up the previous comment, so you
Yep.
said under the current regulations, we actually have to give our information when we being requested if we breaking the COVID measures or not?
Well, they have to. Yeah, here's the thing. So if there's an offense, if you don't produce your identity, then you've essentially, you will be charged with an offense. And pursuant to a lawful arrest, they may search you. They may do what's called search incident to arrest. They may search you for your identification so that they can actually charge you. They're allowed to do that with a legal arrest. And unfortunately, and I don't like how it's written, I completely, utterly disagree. It should be challenged.
Yeah.
It's 8 months in and it hasn't been challenged,
Yeah,
but
so
you should not have to produce it, but you have to. Yes.
So what I've been saying up to now is if people interact a bylaw officer by themselves, they're not like part of any business, I just said just walk away. You do not have to, because the bylaw officer cannot detain you, right? They can call police officers for help, but individuals bylaw officer, they can ask for identification, but I'm not giving it to you and I'm just walking away. What are you gonna run after me, detain me?
It's true. But again, this is all very controversial. If we didn't have the G20, if we didn't have the carding, if that none of that ever happened, there would have already been mass arrests.
Yeah.
They
so
would have already.
So just to kind of maybe wrap it up and this phenomenon, people we were well above 100 people throughout this whole time, 120, 130 people, a lot of people making comments and very valuable information. Thank you. So what I've been saying to people, treat bylaw officer like you treat a parking enforcement ticket guy. That's it. And then you know,
but that they do have an extra right, which is they do have the right to ask. They do have the right to demand, not just ask, to demand under color of law, under the laws as written, your identification. And if you do not produce that, you will be charged with. They can arrest you. They can call the police and arrest you.
They can call the police, but by the time they do it, if you want to run after me, whatever. But at this point, again, we want to challenge this, right? So if the police comes and wants to issue me a ticket, I actually want to get it. The other question that I have for you is we have actually a lady that got a.
I think just to be clear to everyone who's watching, honestly, produce your identification so they can give you the damn ticket. I'm saying that. I'm saying actually, don't get dragged off like the guy in Alberta in Edmonds and Costco. I know it's objectionable. It's like papers, please. I know it's objectionable. You want the ticket. You want it so you can fight it. You want it in your name correctly so you can take it to court, retain counsel. We can do this together and we can challenge it in court.
Yeah. Okay.
Please.
Okay, good.
That's it. So go on.
Yeah. And that's why I'm glad you said in the correct name, because even Chris Sky, 3 times they gave him the ticket. They actually made their own name on purpose.
That's it.
You can't challenge it in court, but they just wanted for the news that Chris got a ticket, right? Following up on the Trespassing Act. So we actually have a lady that got issued a trespassing ticket from Indigo store, and it's for
Perfect.
$65. So off this call, we'll connect and we'll see what's the best course of action for her. Okay.
I would say definitely, yeah, but she needs a paralegal, whatever, it's $55 or whatever it is. So, yeah, I would say it's POA. Apply for a court date per the back of the ticket if you can. Hopefully you can electronically. Um, and then challenge it. Table the evidence with a proper paralegal who can table the available evidence and say, just on the law alone, they do not have the authority to issue a ticket. If you've cited an exemption under the law, they do not, and the police never had the authority, or whoever issued the ticket do not have the authority to even issue that ticket because of its contravenes human rights code. So you present a little bit of evidence and that's it. The evidence would be an affidavit, essentially her sworn statement, and then there would be her counsel asserting the laws that I named on this call, and that it would be dismissed in court. But again, it's POA court. She'd win. I would hope she asks for costs under section 24 subsection 1 as an appropriate and just remedy for clearly disobeying the law. She should get costs for the paralegal as well, and not have to pay anything out of pocket at the end of the day. So I think that's the way she should go, and we'll discuss it after, but that definitely retain paralegal and table the evidence and cite the law as required, and she'll beat the charge. But it's a low precedent. But they won't appeal it. It's nonsense.
And then somebody in the comments saying that the police threatened them with a mischief charge.
Okay.
Within
Again, mischief. What the evidence is the evidence. So they have to. The police have to have an evidence, and maybe I don't know, if you start screaming at the police or whatever, they might say that's mischief. Or if you're skulking around somewhere and you won't talk to them or whatever, you won't, and if you're doing something that constitutes mischief, I don't know what you can look at that act, the mischief act or whatever it's called.
But then that's why it's important to stay cool and collected and just be calm, right?
Yeah, and all you have to do is you can assert your right to silence after you've asserted your rights.
Exactly.
But I would assert your rights, and otherwise, like this, if you could see, police will often, this is the police when gathering evidence, and they think, irrespective of whether they're right or wrong, they will, their job is to gather evidence. So in Costco in Edmonton, the police officers started saying all this nonsense about, you don't believe the virus is even real, because they want you to say stuff like that, because that'll be used against you in court. They want you to appear like a crazy person who's really not citing a valid exemption. The point to do is to assert the law, and I wouldn't even mention the evidence. Don't mention. This guy did. He was like the mortality rate and all that. You don't need to. That's for court. The police officer, it's not going to sway the police officer. The police officer isn't going to go, oh, I didn't realize the excess mortality from February to July was lower than normal. The standard deviations, it's well within this one standard deviation. Like, it's not going to, the cop is going to go, thank you very much for that. You've really taught me a lesson today. It's not going to happen. So the best thing to do is assert your rights, assert under the law, say you have an exemption, and I don't have to provide proof of it. And this is the law. These are the laws that allow me to do that. The local laws, the regulation for the province, the regulations, orders, whatever. And then also the Human Rights Code, and the Trespass Act is the Human Rights Code is superior. It's paramount to the Trespass Act or to mischief if somehow they think it's mischief. But the point is to always state calm and collected. I know this is extremely frustrating. I know a lot of people are ready to bust. I know it. I get it. But I get furious all the time, like thinking about these violations of our rights. But when dealing with the police and dealing with business owners, Like literally, I don't think, I think if you've been a Costco member for several years, I don't think that you really think Costco are they're a bunch of scumbags, that you hate them, that they're contemptuous of the Constitution, that they just want to screw you over. No, the Costco has been very good to us, and I've said that for Good Life. Good Life is, I broke my toe at Good Life. They were I didn't go after them or anything. They were very accommodating. And that's that. So it's very important to say that you like Good Life, that you like Costco, that you like 7-Eleven or any other private business that is supposedly denying exemptions, that you like them, that you find it convenient, that you find their services superior, that you go to small business too, but sometimes you go to Costco because you appreciate their service and what they have. So and that goes to when you're right at the front door and you're trying to get in. Don't get angry at them. Just say, these are our rights. Listen, I'm just asserting my rights under the law as written. That is the law, and the contract law, as stated with Costco, the contract that I've entered into Costco, that hasn't changed. It has not changed. It hasn't. You can produce that too for April 19th, April 1st, April 1st, 2019. So anyway, I'll leave it at that. I know there's a lot of meat on this bone for the call that we've had. I could probably, I know I can and I will summarize all this stuff up. I will put all of this in a PDF file, as a Schedule B, as I call it, with all the appropriate cited legislation, which you could produce to the police, to Costco, to anyone, and
then
say these are the laws.
we can
Yeah.
upload it to our website under resources, and people easily can download it. And we really appreciate your assistance, Chris.
Yep.
That's
For
really
sure.
exciting.
Just fight it. That's the bottom line, is be respectful to all of them. If they want to arrest you, let them arrest you. Let them detain you. Let them search you. It's at the end of the day, that's going to be a lot of money out of their pocket. And people are going to learn a hard lesson, that people's rights are not to be toyed with.
No.
They're going to learn a hard lesson. Let them take you. They won't, irrespective of the quarantine camp stuff, that hasn't happened yet. Maybe it will, maybe it won't. There's a lot of fear mongering over that, and rightfully so. I think we should all be very wary about it. We should be, we have to be kept up to date on all those developments. But if they take you into custody now, it's an arrest. They're not going to put you into jail. They're just going to cuff you. They're going to read you your rights. They're going to give you a ticket, and then they're going to let you go. Exactly. They're going to search you. But even with the search, under arrest, if you have a bag with you, a closed bag, they can't search that. They may ask you, they may say the dogs will tear it up. They may ask to search your car. They may try to walk you to your car. They cannot. That's all illegal. They're not allowed to search anything other than the immediate vicinity, and they cannot go into a closed area. So even your pocket, they can't go into your pocket. They can put their hand over your pocket, and there's nothing in there. If they have keys in there, they can go into the pocket. If you don't have anything hard in there, then they can't go in the pocket. They can only do something that could hurt them.
Sure.
They're not allowed to. That is a right they do not have, even search an incident to arrest. And this was established in a case. I know I've over explained this stuff, but the Supreme Court decided in 2004 in a case, RV Mann, where that there was a guy who had cocaine in his shirt pocket, and it was thrown out. That was thrown out because they did a search for it. They didn't have a warrant, but it was a closed pocket. You can't do that. You can feel, and if you feel a lump, tough. Doesn't matter. That doesn't constitute grounds to search. So we have a lot of rights in Canada. We have a very strictly held rights, more than the United States, way more than Britain, way more than Australia, way more than New Zealand. We are the shining star. We are the remaining shining star. But we have not stood up to this nonsense. We have not stood up to it, and now it's time.
It's time.
Now, do not comply. Do not consent. Do not obey. We will never give in. We will never give in. We will never give in.
No, it's very encouraging and very inspiring, Chris. This is phenomenal stream. We had a lot of people watching it and still present, so this is fantastic. So hugsofamask.ca under resources. Once Chris finishes, it will be available there, guys. And stay tuned. We're gonna do something, but we're not gonna announce it just yet. And any last thoughts? And then I'm sure people would love to have us back and share the experience later.
I know, and we do need to do a Q&A. We definitely, even if it's a chat Q&A, we got to do a Q&A. People need to ask questions. They need to, I know I've gone over a lot of material here, and we can go over just the laws that I've cited, and they can literally print that stuff out and carry it with them. You really shouldn't need to produce it, but that's where we are right now. So make sure you have it ready to go. You'll have it ready to go. And now with the lockdowns, the lockdowns benefit the big businesses. That's another problem for Costco, by the way. Costco is a beneficiary of the lockdown policy. So asserting these contractual rights that they say they have, but they don't have, and doing it right before the lockdown was announced is something that is very suspect, and would be very interesting to determine in a lawsuit, in the discovery of evidence, to find out what they knew and when they knew it. Is if they knew that a lockdown was coming into place, then they had access to information the rest of us didn't have, and the small businesses didn't have, and that's very, very serious. They should not be coordinating with government, because then that impugns small business, and that prejudices small business. So that's yet another. I can't give you the legal grounds for that, but that's definitely another major cause of action, according to the law, that they're literally going after small business, and they're not coordinating with small business. They're discriminating against them. It's again, all of these are actionable, and they will be tried in court. It's just a matter of when, and regardless of where you are, don't give up and don't give in. That's all I can say. Stay in there. I don't know how long it'll take. It's a war. How long do wars take? How much damage do wars take? Most times all wars destroy all property. They leave like a completely hollowed out economy, destroyed buildings, destroyed businesses, destroyed homes. We don't have that now, but we have the economic equivalent. Thankfully it's not as bad, but it's brutal. It is brutal. They want to bankrupt all of these businesses. They want to bankrupt individual people, all for their great reset. And they've said it. They've outright said it. And it's not a conspiracy theory. They've said it. So the same thing with the certificate of vaccination for Ticketmaster. They've said it. So we have to stand firm and realize that we have it a lot easier than people in most wars do, where you literally will not have a police officer or soldier breaking down your door and taking you into custody at gunpoint. That will not happen. Well, maybe it will if it gets bad enough, but we're not there now. Not even there. I don't even think they're there in New Zealand or Australia. I know that someone who posts something on Facebook, which is incitement, I know that it's absolutely tyrannical, but we're not there yet. So, and as long as we stand up for rights and the stuff starts being heard in court, and it will be heard in court, it will be heard in court. Chris Sky will be heard in court. Finally, December 17th, he will be, and they're going to have to rule on it. So when they rule on it, it doesn't take very long with the POA court to rule on something. It will be ruled upon. These are indefensible charges. So, and they're indefensible violations of the law. They're not in accordance with the law. So as long as you don't give up, I know they want people to give up, and they want people, frankly, to kill themselves. They literally want us to kill ourselves. They want us to go away, crawl into a hole, and just die or kill ourselves.
That's not gonna happen.
Don't give in.
No.
Don't give in.
Yeah. No. It's an important time for us, and I really acknowledge what you said, and I've been saying that for a while. I think it's our responsibility here in Canada as Canadians, because I felt it long before, that we have a responsibility to the whole world and humanity to make a change for the whole world, and I'm glad that you're acknowledging that, and this is definitely a responsibility and duty for us to take action. So anyway, this is amazing.
Thank you.
Exciting. Thank you so much, guys. Any questions, message us. We'll be showing up again. And Chris, have a good night. Thank you.
Thanks, Vlad.